Welcome to Court Helicopter Explainer, the second episode on the Employment Act, Cap 226 of Kenya. Today, we are dealing with the questions of deductions. Are you an employee? Are you aware that your employer has some powers to deduct from your salary? Can you imagine you have worked for 30 days or you have worked as a cashier? In the evening you are told, we have recovered all our money. What do you go telling your husband at home? What do you go telling your wife at home? That you worked the whole day and every money was deducted? Are you a matatu tout? You lose the money that you have been given. What will the employer do with you? Are you an M-Pesa lady? An M-Pesa man? You are float, you are at the evening, you reconcile, you find you have a shortage. What happens when you get a shortage? Are you a waiter in a hotel? Are you a waiter in a bar? Then you have a shortage because a waiter is kept with that. Have you done calculations wrongly? What is the law that deals with when you have done this? Have you been given anything? You are a watchman? Yes. Have you lost the tochi ya jirongo for your work? What happens when you lose the rungu? You lose the spotlight that you have been given to work. Are you working where you are given uniform? You wear your uniform and your uniform is torn accidentally. What happens? Are you going to be told that you have got to pay back that uniform? Are you a teacher in a private school or in a primary school? You lose a pen, you lose a textbook. What happens? Is your employer going to deduct you from this money? All those questions about the powers of the employer to deduct money are found in the Employment Act, Chapter 226, in Section 19, Deductions of Wages. Let us hear what the law says. He says, number one, the employer can deduct your contributions. These are contributions, for example, to SACCOs, your contributions to government agencies, NSSF, and other things. That is the first authority, and it goes that any amount due for the employee as a contribution to any provident fund. That one is okay. Number two, the employer can deduct a reasonable amount for any damage done to or loss of any property in the possession or custody of the employee. If you lose any implement given for you to work, if you damage anything as a waiter, if you have a glass, you're serving juice, it breaks, falls down and breaks, the employer has a right to recover that what you have lost or that what the damage you've done. Free. The employer has a right to recover if you are not on duty. You are employed as a cashier and you are paid daily. Your employer has a right to recover that wages for that day which you never worked. So if you absentee yourself from the premises, don't expect to come back and ask the employer to pay you. That is the third provision. Number four, if you are dealing with money, you are an M-Pesa person, you are a petrol attendant, you are a cashier in a school, or a cashier in a hotel or in a reception, you are the receptionist who receives money. Anybody who receives money, the money that belongs to the employer, if you have a shortage of that money, what does the law say? An amount equal to the amount of any shortage of money arising out of your negligence. 2, if it is about theft, that is, you stole the money, you will pay the same amount that you stole from the employer. Number 4, if you are paid salaries extra than what you are supposed to do, an error happened, your employer gave your salaries 10,000 shillings, your salary is 5,000 shillings, the error, either as he was sending you M-Pesa, your salary, instead of 5,000 shillings, he sent you 50,000 shillings. You are being paid by M-Pesa, instead of you being sent 2,000 shillings, your salary, you are sent 20,000 shillings. Your employer has power to recover the extra money that you are paid. You cannot go to court and say, this money belongs to me. F, your employer can, if for example, you have a case as a father, you have not paid child support, there is a court order attaching your salary. Your employer will have to deduct that what the court order has said. So, if you enter in employment, any court order can deduct your salary. So you know today, don't joke with orders of the court. And any employer who is given a court order to deduct the salary of a person, if you refuse, it is a criminal offense, and we shall deal with that question. Lastly, if it is a loan that you recovered, you asked a loan from your employer gives you a loan. The law says he cannot take more than 50% of your net salary. He must retain at least 50% of your net salary. So there are employers who give employees loan, an advance loan, because an employee has lost a relative, an employee is unwell, an employee's relative is sick, they take a soft loan from the employer. Then that month, the employer recovers the whole amount of it. It is illegal. The employer will only recover up to a half of the net that you are supposed to recover. Then, what happens? We said in number 1, an employer has a duty to recover statutory deductions. The statutory deductions are, for example, SHA, NSSF, pay as you earn. All those are government deductions. The infrastructure fund levy is supposed to be deducted and be remitted to where it is supposed to. Many people have retired, yet when they go to NSSF, they find not even a coin was remitted there. Yet in their pay slips, you will see NSSF deductions that were being taken, NHIF deductions that were being deducted, but they were not remitted. What does the law say? It says, an employer who fails to comply with the provisions of subsection 4 commits an offence and shall on conviction be liable to a fine not exceeding 100,000 shillings or to imprisonment for a term not exceeding 2 years or to both. So if an employer deducts money for your circle and does not remit, he will be fined 100,000 shillings or imprisonment for 6 months or for both. If he deducts your NSSF money and does not, or SHA, and does not remit, upon conviction, a fine of 100,000 shillings or 6 months in imprisonment or both. So that is the law about deductions and how one should do the issues about it. How does the law provide for to know these things? Every employer is supposed to give a pay slip, but the pay slip is only for those ones who work for more than 30 days. Casuals, those who work per day, or task-based people have no pay slip. Then the question in there, must you have a letter of employment? The law of employment talks about oral contracts for employment and written contracts for employment. So there are those ones who have written contracts, they can refer to them. There are those ones who have oral contract. For example, watu wa jua kali, munaelewana, nifanyie kazi, utalipwa. That is a contract. It is an implied contract. So stop saying you cannot go to the labor court. Anytime the employee suffers any illegal deductions, Wakili Dunstan Omari tells you the Employment and Labor Relations Court is available for you if there are any illegal deductions from your way. You've worked. You put energy. You put energy. You put energy. Then your employer deducts your money and does not pay your money. What about the payments of dues? If you are a casual per day, you must be paid at the end of the day. If you are a casual that works for 7 days or 6 days, you must be paid your money. If you are an employee, after 30 days, you are supposed to be paid. And therefore, those who are holding salaries of their employees, those who have never paid their employees, Court Helicopter has advised you, you better pay your employees, and the employees now, you know, if your employer does not pay you, you have a recourse at the Employment and Labor Relations Court. Wakili Dunstan Omari, always a pleasure to bring you the episodes. Keep watching. This is episode 2. Immediately, we are going to episode 3, that is about the labor issues, employee and employer. Thank you very much.